Thank you. This hearing is in the matter of case number CFI 004-2022 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued to the registry on the judge's instructions. The claimant is represented by Watson, Farley, and Williams, Middle East LLP. Lead counsel is Miss Charlotte Bijlani. I apologize. The defendant is not present.
So if I could just let you know that Khaldoon Al-Galayini is on the call. He's a manager at Gulf Wings, and
yes,
he has submitted
sworn
3
a number of
affidavits.
Yeah,
that's correct.
Yes, it's Miss Bijlani, isn't it? Not Biljani. Apologies.
It is, yes. No,
yes.
No problem.
and just for your information, the technical expression is Your Honour rather than Sir.
Yes, sorry.
That's okay. That's all
I'll
right.
make sure I do that going forward.
Right, now, first question is the order in which we deal with things. As I understand it, there is an application for default judgment in default of defence, which hasn't
Yes,
been
Your
dealt
Honour,
with.
I was proposing that perhaps we do it in this order. First, we could perhaps deal with the stay application by the respondent.
Yes.
And then the default judgment that the claimant has made, and then perhaps the application to dispense with service requirements by the claimant, and then the committal application.
Yes, very good.
So firstly, in relation to the respondent's stay application, this can be found at A627 of the bundle. And I'm referring to the numbers on the bottom right-hand side rather than the top right-hand corner. The top right-hand corner is the numbering in the previous bundle, but today I'm referring to the numbering at the bottom right-hand corner of the page.
Thank you.
So the respondent has applied to stay these proceedings on the 4th of March on the basis that they have filed an application for discharge of debt in case number 642/2022 in the Dubai courts. They say that that is the appropriate court of jurisdiction to hear the merits of the present claim and any relevant ancillary actions. And in support of that application is a document labelled Request for Stay of Proceedings. And the stay application is made pursuant to RDC 4.2, which gives you jurisdiction to stay proceedings under your case management powers. And you'll see from the document at A630 in the second paragraph towards the end, the respondent says that the Dubai courts are the appropriate courts of jurisdiction to hear the merits of the present claim and ancillary action. And then in the third paragraph, they say that we respectfully request the court to stay the entire proceedings on the grounds of lack of jurisdiction.
Yes. First of all, an action for discharge of debt is essentially simply presumably a suit claiming a declaration that there is no debt. Is that right?
I believe so. I haven't actually seen.
Well, I assume it's the obverse of your claim for the debt.
Yes, I believe that must be the case. All we've seen so far, though, is the document at A631, marked by the Dubai courts. And the claimant has filed submissions.
That doesn't help me as it's in Arabic.
I think it simply names the Gulf Wings and A&K Trading.
Okay. Yes. Anyway, this is a non-starter, isn't it, in terms of jurisdiction because of the DIFC jurisdiction clause in the management agreement, and because they've entered an acknowledgement of service without any reservation of right to challenge jurisdiction.
Yes, Your Honour, and yes, I believe that's the case. And starting at A634 are the claimant submissions in relation to the application. And on page 2 from paragraph 3, we've set out why we consider the DIFC courts have jurisdiction by reference to what the management agreement says and the judicial authority law.
Let me just look at that. I
Of course.
haven't seen that before. Yes.
So, Your Honour, I think, as you say, the management agreement provides for the DIFC courts to have jurisdiction, but as we've set out, the respondents are out of time to seek to challenge the jurisdiction of this court. And whilst they presented as a stay application, in essence, it is a jurisdictional challenge.
Yes. Yes, well, thank you. I refuse to stay on case management or any other grounds. This court has jurisdiction in relation to claims under the management agreement by virtue of the jurisdiction clause, and there has been no challenge to this court's jurisdiction within the deadline provided for in the rules. In those circumstances, the fact that the defendant has commenced proceedings in onshore Dubai seeking a discharge of the debt is neither here nor there, because this court has jurisdiction and will exercise it. So the application for a stay is refused.
Thank you, Your Honour. If we could then move on to the claimant's application for default judgment, which you'll find it starting from A603.
Now, I have in fact had a look at this because it was sent to me on the papers last week, but it seemed sensible to leave it until today to be dealt with. Plainly, there's been no defence served, so really the only questions that arise relate to the sum of money in issue and questions of interest. Now, as I read the papers, the sum that's claimed in the particulars of claim is let me just find the figure.
believe it's at
Yes,
A16.
it's 1272798.55, and it appeared to me at first blush, at least, that the further sums that you sought on top of that, which was for additional 45 odd thousand, which didn't fall due for payment until the 27th of January, was therefore not appropriately to be included in the default judgment. But you can address me on that. And then the question also as to interest, if any, given the fact that all these different sums that make up the total will have accrued on different dates.
Yes, Your Honour, I think that the difficulty with the sums that are referred to in what is paragraph 10 and 11 of A606, which is the supporting witness statement of Mr. Tebbit, they fell due, as you say, after the claim was issued.
Yes, and indeed after service of the statement of claim, so that in the context of the default judgment for what appears in the claim form and particulars of claim, you're restricted to what was actually due then, unless you amend, and then of course the whole business of response to the amendment arises, I guess.
Yes. I don't know if I can briefly take instructions from Mr. Caldoun on that, but I suspect
you
that
can,
the better.
but what I'm suggesting to you is that all you're entitled to at this stage, unless you can persuade me otherwise, is the 1,272,798.55, and then whatever interest there might be in relation to the makeup of those sums up to the date of judgment. And then you've got obviously the statutory rate on the sum for which judgment is given, running from the date of judgment. Do you want to take instructions?
Yes, if I could just briefly do that by telephone, if that's okay.
Yes. Do you want me to, well, if you switch off your microphone, then you can have talk in private.
Yes, it won't be very long. Thank you, Your Honour. Your Honour, I've concluded taking instructions.
Yes.
It appears that the claimed amount of 1272798.55 includes a deposit amount of $200,000,
Yes.
which is intended to cover these late expenses that accrue following termination.
Yes.
I understand that these invoices tend to arrive after termination because it takes time for people to charge the relevant amounts. So we think it's appropriate that you just proceed with the figure that's stated in the claim form and the particulars of claim.
Well, that means you get the 200,000 instead of the 45 and the 23.
Well, I think the difficulty is that under the management agreement, the respondent was obliged to pay the deposit of 200,000, and that's meant to stay there until these expenses are discharged. So once these expenses have stopped coming in, then the balance would be remitted.
Well, is there any more to come in?
I'm not sure. Khaldoon, could you answer that question, please?
I mean,
yes, Your Honor, typically you get navigation expenses from African countries. You could expect to get handling invoices, fuel bills. The majority have already come in, and usually it follows very aggressively after the termination. Now we're in month 5, 6 after the termination, so we're not expecting much to come through, but we do have a substantial list of tickets and hotels invoices that we're presently processing. So we don't expect, other than those, we really don't expect much to come through. But yeah, it's usually things related to the operation of the aircraft.
All right. Well, it seems to me the right thing to do. You're entitled to a judgment sum that reflects the 200,000 deposit, though obviously you'll have to account for that against whatever expenses still remain to come in, including the 45,000 and the 23,000 that were referred to in January and February. And when the balances come in, then you'll have to work out what sums may fall for a refund, subject, of course, to any other issues that may arise in the context of these proceedings. So default judgment then in the sum of 1,272,798.55. But bearing in mind that 200,000 of that is a deposit, which is to be used to pay expenses which have arisen or been invoiced since the date of the statement of claim. All right.
Thank you.
What about what do you want to do about interest?
Well, interest is to some extent included in the 1.272 figure.
Right.
So the claimant is seeking interest from the date of judgment until the date of payment at the court rate.
Yes. Well, I think that follows automatically, but insofar as it doesn't follow automatically, then that will be part of the judgment. So that's at 9% from the date of judgment. That is pretty much what I'd concluded on paper. So that's helpful. Thank you.
Thank you.
Right. Service requirements next.
Yes. So the application to dispense with the service requirements in relation to the committal application starts at A580.
Yes, I'm looking at present at what is A106, 107 and 108, which was the annex to Mr. Berlini's second affidavit, showing what service had taken place and on whom.
Yes.
So there are two elements that I'm interested in particularly. One is Mr. Ali, and the second is a notice of this hearing.
Yes.
The position on that being, as I understand it, that Al Jalaf are on record for the defendant A&K Trading. They've also said that they have been taking instructions from Mr. Abu Hashima. So I can be confident that Mr. Abu Hashima is very well aware of all that's going on. But Mr. Ali is in a slightly different category. And so I want to know quite what you say about that in the context of service or notification and knowledge on his part.
Yes.
And then we can deal with the question of dispensing with service in the light of what you say about all of that.
Yes, so if I could take you, Your Honour, to our skeleton argument.
Yes.
Which starts at C1.
Yep.
And if I could refer you to page C15.
Yes.
And at the top, starting with paragraph 82, it has been set out what knowledge Mr. Ali has of the freezing order that you issued on the 14th of January. And it's the evidence that we're relying on, or the claimant is relying on, is in particular WhatsApp messages that were exchanged between Khaldoon and Mr. Ali.
Yes.
Just
Yes, well, we can look at those in just a moment. They're attached to his latest affidavit. Is he properly referred to as Mr. Khaldoon rather than Mr. Al-Kalaini?
I say Khaldoon because I find his first name easier to pronounce. I apologize.
How is the right way to talk of you as Mr. Al-Kalaini?
Whatever you're comfortable with, Your Honor, but Khaldoon or Mr. Galaini, that's all good. You can drop the AL, of course, to make it easier.
Thank you very much. All right, I don't wish to be discourteous in any way, that's all.
Not at all, not at all. Thank you.
Yes. Well, do you want to take me to those exhibits to his third affidavit showing his WhatsApp exchanges with Mr. Ali?
Yes, Your Honour. So if I could refer you to page A454, which is a translation of a voice message. The first one on page 455 is from Khaldoon to Mr. Ali, following a conversation.
I'm not there yet.
Ah, sorry.
455.
455, yes.
It's not working. Forgive me, Ms. Bertolani, you may have to help me here. I'm going to the find page bit, but I'm putting in A455 and it's not coming up. Should there be a gap or a full stop or a dash or something?
There's a full stop after the A and then a dash.
Stop. Okay, let's try that. Doesn't do any good either.
Charlotte, I don't know if you know how best to.
I got it. I got it.
Oh, okay.
I was doing it wrong. Yep. Okay. Thank you.
So yes, sorry. Starting at A454, you've got a record of the messages exchanged, starting on the 25th of January and ending on the 26th of January. And at A455 is a message from Khaldoon to Mr. Ali, where Khaldoon is referring to a conversation that they have had. And
Well, I've read all these. What I didn't see, I don't think, was any express reference to the freezing injunction as such. Am I right or wrong?
that is correct, but I think it's evident from the WhatsApp messages that he knows that there's this dispute, and he's offered almost to pay some of the debt, and he's asked for details of the debt.
Yeah.
And the other there is another piece of evidence that I wish to refer you to, unless you wish to spend more time reading the WhatsApp messages.
Well, no, I've read the WhatsApp messages, which is why I simply asked you whether I couldn't see any express reference to the injunction. He knows there's a disputed debt, but of course all this is quite late. This is after the aircraft has gone anyway.
Yes, that's right. The other evidence that I'd like to refer you to is the correspondence from Clyde and Co.
Yes.
If I could refer you to A320.
Yep.
At the top of that page is an email from Clyde and Co. to Watson, Farley and Williams on the 19th of January.
Yes.
This is before the aircraft left Dubai, saying that they have just been instructed by Mr. Abuhushima, Mr. Ali and Mr. Shendi, and to act as a legal representative in relation to this matter. And in the heading of the email, it refers to DIFC Court of First Instance case with the case reference. Clyde and Co say they need more time, but we can expect to hear from them by Friday, the 21st of January. At page A323 is a letter from Clyde and Co.
Yeah.
And in that letter, they only say they act for Mr. Shendi and Mr. Abuhushima.
Yeah.
We don't know why that is, but
well, they say later that they never quit on board. Question can be drawn from the fact that they originally said they were instructed by him.
Yes.
Want me to infer from they advised him about the NS, he wouldn't have been approaching them.
Yes, and we have since corresponded with Clyde and Co, asking that they pass on the injunction papers and our other correspondence, or that they get permission to share his details with us. And Clyde and Co indicated that they didn't have any information about his current address.
Yes.
And I think it's a fair assumption that Mr. Abuhushima must have been, or Mr. or their, sorry, the lawyers of the respondents must have been in contact with Mr. Ali. They must have his contact details. Again, we asked the respondents' lawyers to provide or pass on our correspondence to him, or share or get permission to share his details, and they didn't respond to our correspondence about that at all. So that was the request made to Amna Al-Jalaf.
Well, what it comes to is this, doesn't it? That Al-Jalaf were the registered agents. They, as the registered agents, knew exactly who the shareholders and directors were, who were registered at the time. And if they were doing their duty, must have passed on the information about the injunction to all of those people. And that's really the best evidence you've got, isn't it?
It is, and I believe last week we had an email exchange with Al-Jalaf when we asked them if Mr. Ali and Mr. Abuhushima would be attending today, and they said that they had tried to get confirmation but hadn't had a reply yet. And I can share with you the relevant emails, but it seems clear
I'd
that
like
they must
see
have.
this. I'd like to see this. Thank you.
Okay. One moment, Your Honour. I will just try and share the screen. Your Honour, my colleague is just going to share the email exchange on the screen. Could you scroll right to the bottom? So, Your Honour, I don't know if you can see the email exchanges.
It's very small print. Would you like to read to me the relevant parts?
So on the 2nd of March, hire a lawyer at Watson Farley Williams has emailed Ehab Arja of Al Jalaf Associates asking if Mr. Abuhushima not quite sure why it's saying Mr. Shendi be available for cross-examination, because I think because they gave affidavits and not Mr. Ali. But anyway, if we move up the chain, EHAB has responded on the 2nd saying we tried to communicate the hearing date and details with the concerned persons yet and have not received a reply. And then further up, I've asked, could you explain who it is you've communicated with and by what means? And then I have said on the 3rd of March, could you please come back to us as a matter of urgency? Mr. Abuhushima and Mr. Ali are required to attend the 8th March hearing for cross-examination. Could you please let us know if you have communicated this to them and by what means? And then that's it. We received no reply to that email, I believe.
Yes.
It's not perfect, but I think, as you say, the issue is that the lawyers are on record as the registered agent of A&K Trading. And you would expect that if they are the registered agents, they must be in receipt of the contact details of the registered shareholders and registered directors. They're certainly in contact with Mr. Abuhushima, And you'd expect that Mr. Abishima would be in contact and discussing the matter with Mr. Ali, given the seriousness of it.
Yes. All right.
We have we did try and identify an address by looking through the share purchase agreements, but I believe that the stated addresses for Mr. Ali. So this is, for example, A357. The address is just in the address stated in Switzerland is incomplete.
And this address appears a number of times in documents, doesn't it? But it's the same as it's always incomplete.
Yes.
Yes. All right. So what are you inviting me to find in relation to Mr. Ali? That he knows all there is to know, even if he hasn't been formally served?
Yes, Your Honour. I think we've served on every possible means that we can. We've asked the lawyers for the respondent to Amna Al-Jalaf to tell us, to pass on our correspondence, or to share his contact details with us, and they haven't done so. Clyde & Co have also been asked and have been unable to share our correspondence or provide his contact details, maybe because he's refused for them to tell us, I don't know. But I think we've taken all reasonable steps that we possibly can to serve the freezing order and the subsequent proceedings on him.
I understand that, and it's anticipating where we're going to go at the end of the day. But on an application for contempt, I've got to be confident that at the time the aircraft was removed, which was the 22nd of January, if I remember rightly, Mr. Ali was well aware of the terms of the injunction and acted in such a way as to breach that injunction. And that's a slightly different question from what we've been looking at.
Yes.
I mean, at this stage, I'm happy to dispense with service on him on the basis that now he must know exactly what it is that he is faced with in terms of an application for contempt and all the papers regarding the injunction and so on and so forth. And I'm prepared to infer that from Al-Jalaf's involvement and the various exchanges. But whether that's going to get you far enough in the context of an application for contempt is a different question, as we're looking at a different date.
Yes. Should we move on to the contempt application?
Well, what's the exact form of order that you're seeking in relation to dispensing with service, first of all, so I can see exactly what it is you're after? Is there a draft order somewhere?
I don't believe that we have. I'm told there is a draft. So,
is it in the exhibit to Mr. Tebbit, 587 to 602, or what?
Sorry, Your Honour, I'm just trying to find the relevant page. I believe the draft order was uploaded on the court system. I'm just trying to find it in the bundle.
Thank you.
Apologies, Your Honour, it doesn't appear to be in the bundle. We're trying to establish if it's actually uploaded on the court platform. John, I don't know if you are able to find the application notice on the platform itself rather than the bundle.
We're not in the bundle of documents, but actually going to the events section. Is that what you're saying?
Yes, or I could email it to Charlotte and maybe she could, or we can share it on the screen. Should we share it on the screen? Maybe easier.
If you can do that, yes, I can duck out of this and go back to the case management system and see if I can find it in the events if need be. There we are. I'm looking at the events section now. Which application is it? The application of the 4th of March? No, that's
It's the 28th of February.
right. Right, I've got it. Ordered the applicant has taken sufficient steps to notify Mr. Abu Hashiba and Mr. Ali of the committal proceedings. Right, well, it's going to read, it's hereby ordered and declared that 1, the applicant has taken sufficient steps to notify, and 2, the court yes, all right, that will do. So it just needs the additional words, including a declaration that you've taken sufficient steps. Okay.
Thank you, Your Honour.
And 2 ought to read just a matter of wording. The paragraph 2 should read: the court, in the exercise of its discretion under RDC 52.10, dispenses with the personal service of the application for committal on both Mr. Abu Hashima and Mr. Ali. Okay. It's just a matter of getting the form of words right, but okay, otherwise that's all right.
Thank you, Your Honour.
Okay, let's go back to where we were. Yes, very good. So that then takes us on to the guts of today, really.
Yes, Your Honour, I don't know if you've had the time to consider the applicant's skeleton argument.
Yes, I've spent quite a long time looking at the papers, actually, so I'm pretty familiar with it all.
Well, I don't know what is going to be easier for you in terms of getting to the crux of the issue. Do you want me to address you on the share transfers and what has been said about all of that in the evidence that's been filed by the respondent. And
well, I think the real question is this. I mean, I've read your submissions in your skeleton, and it's clear on the face of it that there has never been any resignation by either Mr. Abu Hashima or Mr. Ali of their position as directors. So they remain technically directors of the defendant company. And the question really that arises is, that being the position as a matter of law with regard to the outside world, what in practice is their ability to control the company? And when push comes to shove, who was it who was giving instructions for the removal of the aircraft? Now, reading between the lines, and it is reading between the lines in part, it appears that Mr. Deebs is the man who has been actually exercising control, and he's the one who presumably, either by himself or by his manager, Mr. Manayat, or whatever his name is, gave instructions to those who were dealing with the plane to equip it, find a pilot, fly it out. I really want to know exactly what your submissions are about that, and therefore what the directors should have done, and what you say they did or didn't do. Technically, of course, they are the people who are authorized to give instructions on behalf of the company, whereas Mr. Deeb isn't. But he would, in fact, no doubt, be a director de son tour, as they say, a de facto director who's given instructions. He's a significant shareholder in equity, I guess, if not in law, because likewise they haven't transferred the shares. But this case raises rather acutely the question of who in practice could and should have done things, and therefore whether it's right to regard these two, who themselves regard themselves as being no longer involved with the company, as responsible in such a way as to commit them for contempt. So that's the central point. You can take it. I fully understand the legalities about share transfers not being effective until they've been registered, and directors remaining directors until they've resigned, and it all appears on the books of the company, and so on and so forth. But it's the practicality of it that I'm concerned with in the context of this application.
yes, thank you, Your Honour. If I could start by referring you to A412.
Yeah.
Which is a letter dated the 21st of April 2021 from A&K Trading to Gulf Wings. And you'll see in that letter that there's a reference to the permitted individuals in relation to clause 5.4D of the management agreement, and that the shareholders are stated to be Mr. Abu Hashima, Aviation House, as owned and represented by Faris Deeb, and Mr. Namir Al Akbi.
Yes.
And then it goes on to say that notices under the management agreement should be sent to Faris Deeb. And I think it is this letter that then triggers the activity by Gulf Wings in trying to get information about the current ownership of the respondent. If you recall, in the submissions that were filed by the respondent, including the submissions that start at 156, I don't know if you want to take a look at those, but they're essentially claiming damages because of the deregistration of the aircraft with the GCAA, and they say that that is the fault of Gulfwings.
Yes.
But as has been set out in the evidence of Khaldoon, if I may call him that, continue to call him that, or address him by reference to his first name, he sets out the position of Gulfwings in relation to the deregistration, which is essentially that they were not provided with evidence of the current ownership of A&K Trading, which the GCAA needed, and that resulted in the deregistration of the aircraft.
Yes.
And this is all dealt with in the third affidavit of Khaldoon from pages A436. Don't know if you would like to have a look at that.
Well, I've read all that, so I'm familiar with that. But yes, 436
So,
you want to look at?
Yeah. And
Yep.
There's evidently an attempt by, or a number of attempts by Gulfwings to find out about the current ownership of the company, and no information is given.
Yes.
When the
This is all very odd.
proceedings were started in the DIFC and the freezing order was obtained, you'll gather from the WhatsApp. Yes, it is odd. That you'll gather from the WhatsApp messages that Mr. Abu Hashima and Mr. Shendi, who was registered as a director but then resigned, that they both refer to Faris Deeb as getting up to no good and being responsible for the difficulties that everyone's facing with these proceedings. I don't have any evidence that this is the case, but I'm instructed that, and I think I mentioned this at the hearing of the application for the freezing injunction, that it appears that Mr. Deeb may have a criminal record, and I don't know whether that has anything to do with the issue of registration of transfer of shares. I can't say anything more about it than that. We have no information about it. But I think what is fair to say is that Gulfwings brought these proceedings for recovery of monies due to them and have sought and obtained the freezing injunction to stop the aircraft leaving, in the knowledge that the aircraft is the company's only asset. And that freezing injunction has been served, as you know, on Amna Al-Jalaf as the registered agent of the company. We've been given share purchase agreements in August 2020, October 2020, and October 2021, and then some documents involving Faris Deeb, which the respondent is trying to say evidence a transfer of ownership to Faris Deeb, and then from Faris Deeb onto Aviation House. But what is odd about this case is that nothing has been changed on the register at all, despite all of these alleged transfers. We've seen absolutely no evidence that the conditions precedent of the share transfers under each of the share purchase agreements have been satisfied. So, for example, there's no evidence that the consideration for the shares has been paid. There's no evidence of fees being paid to JAFSA for the transfer of the shares on the register. We haven't seen transfer forms for the entire chain of events.
I think the obvious inference is that nothing has been done appropriately with regard to the registry in relation to the transfers, including payment of fees and so on. Of course, as you say, the explanation could be that they've refused registration, refused to register the transfers because of a criminal record, but you've got no evidence of that.
I have no evidence.
I don't know if the Jebel Ali Free Zone registrar has power simply to refuse because he thinks the shareholders are unsuitable. I have come across that in the context of the DIFC, so it may very well be the same in all the free zones. Yes. Do you know what power the registrar has?
We did do some investigation about the situation. We understand that they would carry out the usual money laundering and KYC checks, and if it materialised that someone had a criminal record, they may well not register them as the owner. But what we would submit that nevertheless there's been no adequate evidence filed by the respondent at all that properly evidences the transfer of shares.
That's certainly the case.
And I think we can make assumptions about what may have happened behind the scenes, but Al-Jalaf must know the situation.
The only legitimate inference that I think I'm prepared to draw is that the purchase price was paid. I can't see any of these individuals effectively offloading the aircraft and saying they're not responsible for it, unless they've received the 1.7 million or 950,000 or whatever the particular sum was that's referred to in the various agreements. I mean, I think one has to work on the basis that those are genuine agreements. But for whatever reason, none of this has ever made it into the company's registry.
Yes, and as you,
I mean, I don't think one would assume that Mr. Abu Hashima or Mr. Shendi were doing anything other than telling it as they see it, which is that they've given up all interest in the plane.
Yes, but Your Honour, I would submit that particularly in relation to Mr. Abu Hashima, he makes a number of statements in his affidavit which are evidently incorrect. So
yes.
If I could just take you to paragraph 16 and 17 of his affidavit on A353 and 354.
Yes.
He says in paragraph 16, I can confirm I'm no longer related to the respondent since 5th of October 2021. I do not have any interest, and this is due to a failure and delay of the new shareholder to implement their contractual commitments. And then in paragraph 17, he says, I've not been involved in the management of the respondent since 21 April 2021. And he says that despite having had issued Al-Jalaf a power of attorney on the 27th of January 2022, which you'll find at A344.
Yes.
And he says he's doing that in my personal capacity and in my capacity as a member of the board director of A&K Trading Limited.
Yes, well, he plainly knows he's on the record still as a director, obviously. In fact, I think Miss Al-Jalaf, when she turned up the very first time, said, well, I've got to do this because otherwise I can't appear. Someone's got to instruct me. And she was obviously well aware of the position in terms of registration of directors. You may recall she was very coy, would be the nicest way of putting it, about what the position was on the registry, but she knew perfectly well, I'm sure, what the position was. And we had exchanges about her giving you that information there and then, which she wasn't prepared to do. Do you remember all this?
Yes, I do. Go on.
Yes. So that, you know, there it is. The position it's playing she was instructed for the company by Mr. Abu Hashima, and he must have known at that stage that he was still registered as a director.
And
so far, so
yes.
good.
Yes. Your Honour, I'd add that they've gone to a sophisticated international law firm, Clyde & Co,
Yes.
who came on the record on the 19th of January before the aircraft left, and sent their letter during the very, very early hours of the Saturday or Friday morning, if I recall, trying to explain why Mr. Abu Hashima and Mr. Ali had no involvement with the company, yet acknowledging in their letter that they remain registered as directors and shareholders. And I would find it very hard to believe that Clyde & Co didn't advise them of their duties as directors and or at least Mr. Abu Hashima of his duties as a director of the company, which may have resulted in Clyde & Co being swiftly disinstructed. But I think the evidence before you makes it clear that Mr. Abu Hashima absolutely did know that he was still on the record. And he as has been explained in Khaldoon's affidavit, he's a sophisticated businessman, well known in Egypt, and he must have appreciated that he could have resigned as a director at any time, which he evidently has failed to do. And he knew, it's evident from the WhatsApp messages that he knew what was going on, whether with Faris Deeb or anyone else. And he's sophisticated enough to know that he could have taken steps to stop the aircraft leaving Dubai.
Well, we'll come back to that point, because that's the key point at the end of the day, the steps he could take to stop the aircraft leaving Dubai. What is the explanation, or the best explanation that you can give, for why these people did not resign from being directors? Is it to do with the fact that the shareholdings haven't been formally transferred? I can't quite see why you wouldn't resign as a director, even if you remained technically a shareholder. I mean, there's nothing to stop you resigning as a director. All you have to do is write a letter, isn't it? Give notice.
Yes, but one thing that is slightly odd is that from the 31st of August 2020 share purchase agreement, which is the first one that's been put in evidence, it says that there's going to be a change of board of directors, and that Mr. Kara, Mr. Deeb, and Mr. Shendi, Mr. Kara, Mr. Deeb, and Ms. Shendi would be added to the board effectively. Or maybe, sorry, Mr. Shendi's already on the board. But we haven't seen any evidence of that board of director change at all.
No.
It's just stayed with the original directors. So
what does that suggest?
Well, I know
you're not inviting me to find that all these agreements are shams, are you?
Well, it's just very odd that we have these agreements and no change. No change in them.
Some help as to what you think is going on.
To be perfectly frank, Your Honour, I'm not sure what's going on, but it just looks extremely bad and suspicious, where you have all these agreements transferring or being executed. You have significant, well, relatively significant amounts of consideration being paid. There's this aircraft that this company owns that seems to be the only asset, and no proper explanation has been given as to why the register's not been changed. And we were hoping to have the opportunity to cross-examine Mr. Abu Hashima and Mr. Ali today, but of course they haven't attended, and neither has their lawyer. So not only are we unable to cross-examine the witnesses, we're unable to ask questions of the lawyer, who is also the registered agent of the company.
Understood. The only area that you should have direct knowledge of, though, is who it was that the claimants were actually dealing with on a day-to-day basis following the March 21st sale of the aircraft and the management agreement. from the 14th of March 2021.
Yes.
Of course, the sums were being built up and their exchanges with Mr. Deeb asking for sums to be paid. But in terms of what was actually happening to the plane itself, who was it that the claimants were dealing with? They were managers after all, so they must have had communications about
Yes.
where it's going to be used, was it going to be chartered out, who was going to use it at any time, where was it flying from and to, all those sorts of issues.
Yes, I do believe that Faris Deeb was engaging in email correspondence with Khaldoon, and at least until the end of October last year, Mr. Abuhashima was also on the email chains.
But these are all in connection with some money owing, aren't they?
Yes, that's right.
What I was wondering about was there anybody else who was being dealt with, who was they were in communication with about the actual use of the plane? What was happening to it?
May I answer this, Your Honor?
Yes, Mr.
Yeah.
If that would be very helpful.
Okay. We never had a good relationship with Faris to start with. Previous history, court cases, and all of that. So when he apparently showed up as an owner, I maintained my relationship with the supposed owner, Mr. Abuhashima. So throughout, other than on emails, the communication was with Mr. Abuhashima and maybe sometimes Mr. Kamil Abu Ali when he asked for trips or charters. Up till the termination date, I was in touch with Abuhashima. Even during the default, because we served a default notice at some point before their termination, and according to that default notice, due to the sums owed to the company, we had the liberty to charter the aircraft only. And at that time, Mr. Abuhashima was making direct payments to us to allow him to fly as a charterer rather than an owner. And at times he put us on calls with Faris and he said, Faris, why don't you pay them? And I would call him back and say the money didn't come through, and he would say, oh my God, what a loser, why did he not pay you? Up to the point when when they served the notice, we were still in contact. So the general arrangements were with Amr Shindi and his boss, Kamil Ahmed Abuhashima. When it came to the AMA, the repurchase, everything was mostly almost 95% through Abuhashima and his CFO at the time, Amr Shindi.
Right. Well, that's very helpful. I don't think that appears anywhere in the evidence, does it, Ms. Bajlani?
No, I don't believe so.
That's news to me. But I think in all probability you're going to have to put that on affidavit from Mr. Gaialini. But it's a significant point, that.
And at all times, Mr. Faris was informed and updated, and it was basically Faris with accounts, myself with the original owners and the existing owners. It was all over the place. I mean, in terms of Faris, he had some 4 or 5 names that he directed inquiries through, but we knew it was him writing these emails on behalf of finance directors, accountants, and he would sign FD at the end of it. Even though the emails would come from, a secretary or an accountant on record.
Yes. Mr. Gaialini, if this was taking place in the ordinary way in the courtroom, I would be asking you to take the witness box and I'd ask you a number of questions. What I'm going to do now is ask you a few questions, which you must treat as if you are on oath. And then I shall invite Ms. Bajlani to draft an affidavit for you to swear, which recites, in essence, the information that you're giving me. I understand all that you're saying about what actually happened in practice after March 2021, you're saying that so far as the use of the aircraft was concerned, essentially you dealt with Mr. Abu Hashima and Mr. Shendi. So far as payment is concerned, you were looking to Mr. Deeb for payment because that's who they told you to look to. And you kept complaining to Mr. Abu Hashima that you weren't getting paid. Is that broadly right?
In essence, Your Honor, but again, we also reached out to as his CFO to make these payments, and most of the time the confirmations only came through that this payment has been made. He would provide the SWIFT, he would provide the statements. Faris was mostly dancing in the background, saying, I'm an owner. Why do you, why are you defaulting us? Why are you this? Why are you that? And most of the time, I would email him back for formality, but then reach out to Abu Hashima for common sense.
Right. Okay. Now, What about Mr. Al Akabi? Have you ever had any dealings with him?
Mr. Namir, except for one incident where he and Faris kind of set us up to default on a charter flight. And I'll explain what I mean with that. There was not many dealings, except at some point when we grounded the aircraft and it was terminated, I reached out to him and I said, we may have a common target here because Faris, I understood that he was running the terms. I said, maybe you've never spoken to us, but I can explain what's going on to the aircraft, that you might be at risk. Maybe you have one common target. And he said, I don't care about the plane. And then on a second message said, I'm taking Faris to court myself. And that was the end of it. Previously, maybe a year before, when he got on board, there was a charter where it was agreed with my charter manager that he would fly a certain ADC and that would pick up the plane at point D for a charter. And at that point, he actually insisted that he's not getting off the aircraft and asked to continue to be flown to Iraq or Jordan. I failed to recall. And then we just tried to reach out to him to be flexible, and he said, no, that's what I told you all along. But that was a kind of a passing incident. But it turned out that Faris had probably set us up to upset him because he failed to tell him that there was a charter. And the owner said, I never said, but I had the text messages with my sales manager to say otherwise. But again, it was, an okay, yes, I'll commit to the schedule. But then when the flight came up, he just didn't get off the plane. But other than that, Mr. Namir was always in the background, always unhappy from what I heard. And, throughout the year that preceded this, Namir and Faris were continuously talking to crew that they're the new owners and they will take the plane from, lousy Gulf wings and move on. And, they were talking to them about employment and taking them on board, making them verbal offers for employment. This was all happening in the year that preceded the termination, or let's say 8 months, 6 months. The span between the purchase agreement and even before they purchased the aircraft, they were talking as if we wouldn't know. They would fly and they would be charters, they would be chartering, but at the same time, they would speak to crew as if they're owners. I got to know about Namir's intentions to buy into the aircraft much sooner than we had been informed on paper, if at all, actually. I think officially only, other than verbal, officially the only evidence of him being a supposed owner was what was revealed in court about the share transfer agreement, which was again borderline illegal, but as you rightly said, financially they may have bought their share into that. But officially for us, there was no evidence at any point.
Understood. Now, what about Mr. Ali? You had dealings with him?
Yes. Mr. Ali was always, came on board late. Original buyer was Ahmed Abu Hashima. Then he got the Kamil Ali on board. From my experience with all owners in the past, any aircraft with 2 owners, the second one always feels, kind of second tier or less important. Kamil had repeatedly contested, favors being made for Abu Hashima, and why does he pay the same? I said, he pays more. He flies short sectors, he flies long sectors. So we met, we flew him, we demoed a new aircraft for him from Marrakesh to Cairo on a Bombardier aircraft. It was always positive, but he would always hide behind his secretaries and refuse to pay for things like, the plane goes tech in Morocco. Next 2 days, while we're trying to troubleshoot the aircraft, he sends a message that he's flown back to Egypt and that we are to take care of the aircraft and its positioning costs. So we go back to Amr Shindi, who is the account manager and the CFO for Abu Hashima, and would say, how can we put this on the statement of account? This should have been passed back to Kamil. So it was ongoing, endless back and forth between a lot of people. But Kamil, mostly it was payments, always late on payments, always late on payments. So many defaults before the actual time when we defaulted them. But we thought that would change when they bought into the aircraft, and initially we defaulted them, we proceeded with the repossession, but then they offered to buy it back, and by concession from the CEO, he accepted for them to buy the aircraft back in March, like they did. So we thought things would get better, and they did not. There was hardly any main payments towards the debt or the account after the purchase. But again, sorry to come back to the question. My dealings with Kamil were not as repetitive or frequent as they have been with Ahmed Abu Hashima. And such is the nature of Ahmed Abu Hashima. He's always calling, following up, asking favors while also asking flexibility. Most of the time he would say the money's in, but it wouldn't be in. So I'd kind of exceptionally give him a flight and call him back and say no money was in. He would blame it on Faris, only to call Faris and Faris to play another game until we had enough of this.
Yes. All right.
Yeah.
Well, that's helpful. Ms. Bajlani, do you want to ask Mr. Galini any questions? You've heard what he said, and no doubt there'll be a transcript of this as necessary, but I think what has been said needs essentially to go on affidavit.
Yes, Your Honour.
As I've said, I've treated effectively what he said as if he was in the witness box answering my questions, but I think it ought to be recorded on affidavit, at least in the substance of it. All right.
Yes, Your Honour.
Okay, we'll deal with the practicality of that when we get to the end of the hearing.
Yes.
In the light of those answers, are there any questions you want to ask him, or any submissions you want to make in relation to what he said?
Your Honour, I think it's clear that Mr. Abu Hashima and Mr. Ali have sort of been involved with the aircraft, despite these share transfers, and Gulfwings are aware of Mr. Faris Deeb. Indeed, he appears on the share, the trust documents. If you recall, there was a trust agreement that was exhibited, I believe, to the first affidavit of Mr. Oliver Tebbit at the start of these proceedings, and in support, I believe, of the injunction application. I don't know if you want me to take you to those documents, but Faris Deeb was named on or signed off on the trust document that purports to transfer the legal title to TVPX, and then the lease back of the aircraft to A&K.
Yes.
So Faris Deeb has been in the background for some time, as is clear from what has just been stated to you by Khaldoon, and as is clear from the emails that have continued to be exchanged in relation to the non-payment of the debt. But I think in the context of the injunction, Gulfwings have done what they needed to do, which is to bring it to the attention of the registered directors and shareholders as best they can, and the registered agent of the company. And I think there's sufficient evidence before you that Mr. Abu Hashima, and we would say Mr. Ali, had not sufficient knowledge of the injunction as you referred to earlier, Al Jalaf should have exercised their duty to make sure that they are aware of the injunction and what it says and what it requires them to do. There's no evidence that they've taken the step of resigning as directors, which they could have done at any time. And I would submit that they evidently did know, and they're sophisticated enough, both of them, to know that they had duties as directors, and they failed to do anything at all, we would submit, to stop the aircraft leaving. And it's also telling that Clyde & Co., an international law firm you'll be familiar with, came on the scene and swiftly were disinstructed, or decided maybe perhaps not to act any further, but they undoubtedly would have advised the respondent, Mr. Abushima and Mr. Ali, of their duties.
Yes.
So whilst Mr. Deeb may have been evidently in the background, and whilst Mr. Deeb may have had some involvement in procuring the departure of the aircraft from Dubai, Mr. Abushima and Mr. Ali were legally responsible to ensure that the aircraft did not leave.
Right. Well, let's assume that's right. The question then is, being legally responsible, what in practice could and should they have done?
Yes, Your Honour. So we've set out at paragraphs 81 and 87 the steps that Gulfwings say that both Mr. Abushima and Mr. Ali could have taken to stop the aircraft leaving. And I'd like to just explain that this is in the context of advice, as I said, they presumably received from Clyde & Co. And subsequently Al Jalaf, although it's unclear exactly when the advice from Al Jalaf would have started. But we set out, and the paragraphs are identical, 81 and 87 are identical, because we say that they could have each taken their own steps, and the same steps apply to each of them because they're both registered directors and shareholders.
Well, let's just look at this.
So the first step we say that they could have taken is to notify the GCAA of the issuance of the freezing order and inform them that the aircraft should not be allowed to leave.
But you served the injunction on the GCAA anyway.
We did, although it was not taken notice of in the way that it should have been. It's not entirely clear why that is the case. We know that Al Jalaf have said in their submissions that the order is not enforceable because it hasn't been approved by the onshore courts. And I think it's fair to say that the GCAA may have taken that view, but I think I've addressed you previously that the DIFC freezing order is, as a matter of law, enforceable until it's discharged by this court. And that was certainly the position that was taken in an earlier DIFC case, VIH Dubai Palm Jumeirah and Assas Opco, which I addressed you on at the last hearing, where a similar situation was considered with a freezing order in relation to a hotel management arrangement not being complied with because it was considered to be unenforceable on shore. And the finding in the Dubai Palm case that it was enforceable immediately as soon as it had been made and served. And it's no excuse to say that it's not enforceable because it hasn't been approved by the onshore courts.
Well, it's a question of who it's enforceable against, isn't it?
Yes, so I think Gulfwings say that efforts could have been taken to notify the GCAA and make sure that steps were taken. we were notified. I myself was, if I recall correctly, on the night that the aircraft left at around 1 o'clock in the morning, I had a conversation with a person in the legal team at the GCAA, and it appears to have all been a bit too late. The freezing order was issued on a Friday, and I believe that the aircraft left on the Saturday. So there was no practical time for us to actually go and have the onshore courts recognise the judgment in the way that you could do. But I would submit that this freezing order came to the attention of Mr. Abu-Hashima on the 14th of January. That is evident from the WhatsApp messages that were exchanged between Khaldun and Abu-Hashima. He was sent, or certainly received, the freezing order by WhatsApp message, so he knew of it on the 14th, and he had much more time to try and stop the aircraft leaving than we did as the lawyers for Gulfwings. And we submit that he could have notified the GCAA in good time to ensure that the aircraft did not leave.
May I add something here?
Yes, Mr. Galley.
I would also imagine they could have reached out to us, because I was in touch with Ahmed Shindi in the week between the freezing order and the departure of the aircraft. And I said, Faris is trying to do this. Because, again, speaking with the knowledge that they had, given us, that Faris is running the show, I said, well, he is. Because Ahmed Shindi was reaching out to me to remove him from the claim of the freezing order, or the place, remove his name from the freezing order court case. And I said, well, he's trying to do this, he's trying to do that. And he said, well, sorry, what I'm trying to say is they could have also asked us what they can do to prevent a departure. Because I said he's talking to executives, I see N registration, I see placards on the aircraft. These are all indicators that the plane is being planned to be taken out of the UAE. At no point did they reach out to us and suggest, what measures can be taken to prevent that, even though they could.
Yes.
Yeah. And the least we would have advised is to inform, because we knew exactly where this was being done with Executive Maintenance Center and Falcon Aviation. We would have instructed them exactly where to go and with whom, to make contact to prevent this departure.
Yes. All right. And one assumes that in those circumstances, there would have been an issue as between the legal directors and one assumes Mr. Deeb. From whom were those who were responsible for actually taking the plane out or making the arrangements? Who were they going to take their instructions from? Yes, I mean, the most compelling point, I think, Ms. Bijlani, that you can pray in aid is that at no stage did either Mr. Ali or Mr. Abu-Hashima come to either you or the court or to the claimant and say this is what the position is following the 14th of January injunction. And even now, all that we actually have from Mr. Abu-Hashima is some nonsense about the transfer of the ownership and the defendant company therefore not knowing what was actually going on at all, which is transparent nonsense, as they're the beneficial owners and TVPX are simply owner trustees. I mean, that I think is very damning evidence. It's an extraordinary affidavit from Mr. Abu-Hashima, I think.
Yes.
It's almost word for word the same as the submissions made by Ms. Al-Jalal. And there may be a couple of extra paragraphs where he says, I wasn't a shareholder and I haven't been involved and so on and so forth. I mean, it's bizarre, really. Actually, I've confused the issue. It's not Mr. Abu Hashima who says that I didn't know what was going on. It's Aviation House who say that. Anyway,
Yes.
there we are.
I think, as you correctly point out, Mr. Abu Hashima says that he's not related to the company and not involved in the management, which is just not true, bearing in mind the POA that was then issued. He also refers to alleged failures on behalf of the new shareholders, but it's evidence from the August 2020 and October 2020 SPA that as a transferring shareholder, he had covenanted to ensure that the transfer was reflected on the register and that new share certificates were issued to the new shareholders. And under the October 2021 share purchase agreement, he had covenanted to actually issue a POA to Mr. El Akbi, authorizing him to change the register. And there's no evidence of any POA.
Can you just show me that? I haven't picked up those points. Can you just show me in each of the agreements the provision concerned?
Of course, Your Honour. So firstly, with the August 2020 SPA, if you could refer to page A358.
Yeah.
And at recital C at the end, it refers to there going to be the intended execution of the final transferred shares as defined below, sale and purchase documents, the SPA. And then at paragraph 2.2, it states that the parties shall enter into the SPA and other ancillary documents.
Yeah.
And then 2.23, the first party and second party, the first party being Mr. Abu Hashima, the second one, Mr. Ali, shall undertake to make the necessary amendments to the company memorandum of association of articles to reflect the transfer of the shares to the third and fourth party. And then 8.2.2, there's a covenant by Abu Hashima and Mr. Ali to procure and ensure that the company issues share certificates immediately after the conclusion of the SPA and reflect the amendments.
Yep. And can you just give me the cost references to the other ones?
Yes, so the next affidavit, the next share purchase agreement in October 2020 at page A382, clause 2.2, as an obligation to enter into the SPA and ancillary documents.
Yeah.
And at 5.2.4 is the covenant to procure that the company issues the new share certificates and amends the memorandum and articles.
Yeah, what's the reference again? 358, did you say?
A358, clause 5.2.4.
Yeah.
And then the 5th of October 2021 SPA between Abu Hashima and Mr. El Akabi. There is a covenant at clause 3.2,
Yeah.
whereby Mr. Abu Hashima covenants to issue a power of attorney to Mr. El Akabi to represent him before all governmental and non-governmental authorities and entities to reflect and effect the full exit of him from the company.
And the reference to that page?
Is A394.
Right. But nothing about procuring the issue of share certificates in that agreement.
Don't think I could. I think under this agreement, it was done rather slightly differently in that the second party was going to take control of making the amendments under the POA.
Yes, that's the whole point of the POA. Yes.
Yeah.
Yeah, got it. I was just looking back to the earlier one. 5.2.4 you said in the October 2021. I can't see 5.2.4.
In the October
2020.
Yes, that's on page A385.
Oh, right, okay. Yeah, thank you. Yes, okay, well, I've got that.
So yeah, I think it's clear that Mr. Abu Hashima has made a number of false statements in his affidavit, and it just does seem to be almost a copy of his lawyer's affidavit.
But it's almost, it is word for word the same, including the mathematical mistake in the table at paragraph 11,
Yes.
isn't it?
Yes.
Which are the different bits? Just the only different bits are the paragraphs where he refers to his shareholding, I think.
Just going to quickly check that. I believe that Ms. Al-Jalaf's second affidavit has sections in that are not in
but basically,
Abu Hashim.
Abu Hashima, paragraph 1 through to 15, I think word for word the same, aren't they? Subject to changing I.
Yes. Yes, that's right.
Pretty much so. And so it's paragraph 16 onwards that is different.
Yes, and which is, I would submit, false. The statements in paragraph 16 and 17 are not true.
Yeah. All right. What next?
I believe that Al-Jalaf's second witness statement is also the same as this affidavit given by Aviation House as well at A416.
Which paragraphs are the same?
I'm just told that they're the same, but I think, sorry, apologies, Your Honour. I think in the context of where they say that we're not in a position to advise the court on the relevant events because of the transfer to TVPX. I'd also, I'm sure you've picked it up, but it's telling that they don't mention at all the lease back, immediate lease back.
Yes. Paragraph 8 is in exactly the same terms as paragraph 7 of Al-Jalaf 2 or 1, is it? 2.
2.
Yes, they haven't gone to any great trouble in relation to these affidavits.
No,
yes,
we did have a struggle after your order on the earlier to get the actual register itself, which you may have noticed. But Your Honour, if I could just take you to 2 pages which do show that Mr. Ali was sent a copy of the freezing order. Sorry, and a copy of the committal application by email.
Yes.
Gulfwings provided us with the email address for Mr. Ali, and this is referred to on page 584, A584. Which is part of Mr. Tebbett's witness statement.
Yeah, which paragraph are we looking at?
This is paragraph 14. It appears that the email was relayed, but we didn't receive a read receipt.
Got it.
And that's shown on page A593 as well. Where it says delivery to recipients is complete, but no delivery notification was sent by the destination server. And I believe it's the same email that went to Al-Jalaf.
Yeah. Yes.
Your Honour, I don't know if you want me to continue to take you through the steps we say that they could have taken to stop the aircraft.
I don't think so. No, I think that's good enough. Thank you.
I think that is all we have to say in relation to the committal orders. I have included in the skeleton argument a position concerning an order for damages.
Well, I'm afraid that's a non-starter, isn't it? You know it is. It's not pleaded. It's not in the statement of claim. If you want to pursue that, you'll have to start again.
Yes, I think this has all been moving rather fast, and I think, Your Honour, you know, I think the feeling is we've hopefully I think we have obtained a full judgment, and it's unfortunate that
you've got a judgment against ANK for what good that will do you. I don't know in terms of enforcement, but there it is. You can see what take it to states or whatever, enforce against the plane. The real question, and it's not for you to tell the court what the court should do in relation to an application for contempt, but you're seeking, as I understand it, orders that are to be made against the individuals, Mr. Ali and Mr. Abu Hashima, but you're also seeking an order as against the defendant itself. Is that right?
Yes, I believe that is what the committal application requested. Yes.
Yes. So I can fine the defendant, and I can fine both the of the two individuals. Is that right? My powers extend to that in the context of the DIFC.
I believe that is correct. If you could allow me one moment, Your Honour.
Well, it's 5237(3) that I'm looking at.
Yes, I have that in front of me now.
So if I was to think that prison was an appropriate idea, I'd have to refer the matter to the Attorney General.
Yes.
Because I don't have powers in the DIFC to, as I would in the UK, to call the tipstaff and have them hauled off to prison. That doesn't arise. What's more, since they aren't in the jurisdiction, that, on the face of it, has little pragmatic effect.
Well, I think we're aware that Mr. Abu Hushima in particular has been in Dubai over the past week or so and is a regular visitor to Dubai. Right. So the effect of you actually referring it to the Attorney General could result in a travel ban and other measures against him.
Right. Well, that was the question I was really aiming at. What in fact is going to be most effective here? I mean, at the end of the day, the claimants want to be paid their 1.2 million. If I was to fine both of the individuals, it would have to be in a significantly large sum to have any real prospect of a salutary effect. It may be that they could come back and purge their contempt in some way, but it's hard to see how. But you're entitled to make submissions as to what would and would not be an effective sanction that the court could impose, or steps it should take in relation to the Attorney General. So you must have thought about this. Do you have submissions to make?
Yes, I think the preference would be to make an order referring the matter to the Attorney General, because that is likely to have the most impact in terms of effectively securing a travel ban and or an arrest on arrival in Dubai, because Gulf Wings considered that Mr. Abu Hushima, I can't really comment on the movements of Mr. Ali as much, but certainly from his Instagram account, he seems to have been in Dubai over the past week and is a regular visitor to Dubai. I think if you were to exercise, and I think the powers in 52.37 are in the alternative, so I'm not sure that you can make an order referring the matter to the Attorney General and fine him.
No, I don't think I can. I think it's one or the other. The Attorney General order, basically, it's the equivalent of what in England would be a freezing order, an order of imprisonment. You know, it's because I don't have the power to imprison as a civil judge in the DIFC. It has to go to the Attorney General. Whereas in England, I would simply sentence to an immediate period of imprisonment for contempt of court. You know, I've got power to do that for up to 2 years, I think it is. 6 months to a year is usually the maximum. But from your perspective, your client's perspective, what they really want is to be paid.
They want to be paid, indeed, and that's why we're here today, because one, they've ignored your order, Your Honour,
Yes.
but as you sure have picked up that this is the only real leverage that is available at the moment to try and secure payment.
Yes.
My concern with the fine as well is difficulty with having it
Enforced.
enforced.
No, I understand. No, don't worry, I've got that point. So it's a question of what is likely to have the maximum impact. Is there a draft order that you've produced somewhere?
Yes, I believe there is. I think the easiest thing is to share it on the screen again, if that's okay with you.
Well, it must be attached to your application, mustn't it?
I do recall having
Just see.
prepared a draft.
Where's the application to commit?
I think it's A337. It must be the draft order.
Yes.
But that, well,
Recitals, yeah.
I think having looked at rule 52.37, we would have to look at removing paragraph 6.
Yes, well, it's not, as a matter of theory, impossible to both fine and imprison someone. I recall doing that as an assistant recorder, and the Court of Appeal telling me that that was a silly thing to do many, many years ago in Britain. So it's never done in practice, though I've always thought there's a measure of sense in it. But in practice, if I'm going to refer, I shall refer, and I wouldn't fine. If I was going to fine, I would fine and not refer. So it's one or the other. The form of words that you've used, is that a form that you've got from somewhere else, or is it simply what you've created in paragraph 5?
I believe it's something that we have drafted, yes.
Right. Well, I shall probably play around with that. Yes. Seven is not right, is it?
I'm beginning to think that we must have looked at a template of the order to put that in.
Where would you have found that?
I'm not sure if that's referred to. I'm just checking if it's referred to in the rules.
You may want to have a look at that, and but it appears to me that if what I'm going to do is to make an order referring the matter to the Attorney General, what it needs to provide is that the individuals, and indeed the company, because you haven't dealt with the company here.
Yes.
You know, one might well find the company. I don't know. They have permission to. They don't even need permission. Just say, Mr. Abu Hashima and Mr. Ali and the defendant may at any time apply to the court to purge their contempt. purge is the expression that's used,
Yes.
which means that in practice they have to turn up, apologise, and say what they're going to do to show they're really sorry. Like pay the amount of money that's being claimed would be a nice start,
Yes.
but we'll see. I will play around with that, and in fact what we'll probably do is send you get the registry to send you a draft of the order that we're proposing to make for your comments before we finally issue it.
Thank you.
I'm not conscious of ever seeing a committal for contempt taking the form that you've put here, but if there is some form of template that's been used elsewhere, then I'd be interested to see it. But as I say, it's not the way I do it ordinarily.
Yes, we'll check how we've arrived at paragraph 7.
All right.
Yes.
Well, you can work on the basis that I'm going to make an order that refers the matter to the Attorney General in relation to Mr. Abu Hashima and Mr. Ali. And the other question which remains is what you want me to do about the company.
Yes, because, well, I believe you can make a committal order against the company. As
why would I be doing that?
What effect would? Well, I think but in the application we've made, I think it refers to the company, but
it does refer to the company, but not in your draft order.
No. So I think if you have jurisdiction to do so, it would be, which you appear to have under 52.28. So if I got that wrong, 52.37.
Yeah.
Is to make a fine against the company.
Yeah. Well, that's what I was thinking.
Yes. Yeah.
It doesn't in a sense add very much to having your default judgment. You don't get the money. It's just a punishment.
Yes.
But I think it makes sense to do it just the same in order to encourage payment.
Yes.
Yes. All right. Well, I'll make provision for that as well.
Your Honour, I think I haven't mentioned the costs of all of these proceedings.
Yeah.
I appreciate as well that may be a pointless task to some extent, but I think we would prefer to have a ruling on costs.
Yes. Well, you're plainly entitled to your costs. The only question is the amount. Have you put in a schedule or anything?
Yes, Your Honour, it's right at the end of bundle A, starting at A638.
Ah, yes.
I have to say it is a rather high amount, Your Honour, and I'd explain that by reference to the fact that there's been a lot of activity, particularly following your freezing order, in the lead up to the departure of the aircraft and finding out what had happened, ensuring service by various means, preparing numerous affidavits and witness statements, and attending, I believe, 3 hearings in total.
Majority of the time is yourself and Mr. Tebbit.
Yes, so Mr. Tebbit is a partner in our London office, who's been involved primarily due to the fact that he's an aviation finance lawyer, and has the initial relationship with the client, but he's needed to be involved due to his aviation expertise.
Yes. Why haven't you got any rates specified?
The rates are specified on page A639.
Right. They're not specified on 638.
It's on. I think if you were to click on the actual statement of costs on the court website, you would see the rates. I don't know why it's not shown up on the printed copy.
So what is involved in other work not covered above? We've got the usual headings of attendances on opponents, attendances on others, documents, work done on documents, and so on. But what's covered by other work not covered above?
I believe in particular hearing preparation has been included, as well as various communications, extensive communications we've had to have with JAFSA to understand how they implement the company regulations and what actually the process is, and whether or not they would register someone with a criminal conviction. There's been time spent, for example, by Maria Ivanova in relation to that, and Haya Albawab. And my time, I think, is predominantly for the various hearings.
Yes. What's Ms. Haya Albawab's time? Did you say? Is that mostly JAFSA stuff?
I believe so, and also I believe she's attended to effect personal service
yes.
of various documents, in particular on Al Jalaf and others.
Yeah. Mr. Whitfield did a lot of sorting out the documents, did he?
He's been working on the bundle and is responsible for that insertion at the front with some unfortunate lettering. But yes, he's worked on the e-bundles.
Yeah, well, it isn't cheap, is it?
No, Your Honour, I admit that.
Well, there we are. It seems to me that in these circumstances, this is a case which is outside the norm, and you're entitled to costs on indemnity basis. Well, you can have what you ask for.
Thank you, Your Honour.
Full sum, $288,017.67.
Thank you.
Wow. Well, there we are. All right. We'll draw up the order. I'll draft some reasons. Hopefully you'll get those sometime tomorrow. We actually may not get the reasons tomorrow, but you'll get a draft order tomorrow to look at, which you can then revert with any submissions you want to make on the form of it. And then I can approve it later this week, and it can be issued, and the reasons can come with it as well. And then it'll all have to be served on the individuals concerned again.
Yes, could I just ask when you would like the further affidavit? We'll obviously prepare that as quickly as.
How quickly can you do that? I've made a note of what Mr. Galagini has said. So it's just a question of practicality as to how quickly you can do that. But I'd certainly want it done before the order is finally made and the reasons are given, which is likely to be in a couple of days' time.
Yes, so I'm just conscious that we need to get the affidavit sworn. So
Yeah.
I think we could draft it this afternoon and then have it sworn as quickly as possible tomorrow. And
Yes,
then
well,
submit it.
in one sense, there's no particular rush about this because, you know, the defendants haven't appeared, none of them have turned up, and you know, nothing is going to happen very quickly in any event. So as long as it all gets sorted out in the next three days or so, that would be perfectly all right.
Okay, we will submit it as soon as we can.
All right. Is there anything else you need to raise at this stage?
No, I don't believe so, Your Honour. Thank you very much for your time today.
Okay. All right. Thanks very much indeed. If you'd like to sign out, in fact, if everybody would like to sign out except for Charla, I'll have a word with her.
Okay, thank you, Your Honor.
Thank you very much.
Thank you very much.
Thank you.
Thank you.
Bye-bye.